Welcome everybody to Nyaya Prasadam and the sessions on jurisprudence. Today's session is about the different types of liabilities and liability itself. The different types of liabilities include vicarious liability, strict liability, and absolute liability. Please note that there are often appearances from this part of the session either for the entire liability section, including whatever I am going to talk right now, the entire particular session video or the session content, or the specific types of liabilities such as vicarious liability, strict liability, and absolute liability. One of this is very frequently appears in your examination, so prepare well, and I'll also take you through this in a bit detailed way so that you are able to address the questions in the simplest and wonderful manner. So now let's understand what is a liability. Liability is primarily a responsibility for an act or omission by either by self or by someone else. So when there is a liability, now to remember the different types of liabilities that are there in place under the law, let's have a wonderful mnemonic. We also have heard about the assets and liabilities. Now assets is something seen as a kind of various plus additions, properties, and so on. Liabilities is seen as negatives or subtractions or losses or the payments kind of thing. So when there are liabilities, more liabilities over here, people are often seen to go overseas to get better earnings to tackle their liabilities. So just remember, the moment you see or you hear the word liability, this should pop up in your mind that because of liability, somebody needs to travel to, and in order to travel, they need visa. So this visa is the key word for this question. So liability linked with visa. Very first type of liability, which is civil in nature. And we are not going to talk about criminal liabilities in this session. So let us limit ourselves into civil liabilities. So under civil liabilities, primarily there are three liabilities that we'll be talking about. They are vicarious liability, for which the alphabets V and I stand for. And next alphabet is S, which stands for strict liability. And the next alphabet is A, that stands for absolute liability. So just remember, liability is when liabilities are more, or when there are liabilities, we go to overseas and therefore we need a visa. So visa stands for vicarious liability, strict liability, and absolute liability. So under vicarious liability, let's see what are the different essentials, because this itself is appeared in the examination number of times. So let's go a bit more into details. Vicarious liability essentials are that there must be a relation between the parties where this liability arises. So when I say a relation, this relation must be any one of this, which is either the owner and independent contractor, a relation should be there as such, or either principal and agent, or either master and servant, or either company and the directors, or either partners in partnership form. So in a vicarious liability, it is very essential to have a relation which can be defined in the 5 different types that I mentioned, with either of 5 different types. But don't worry, we have got a wonderful mnemonic to remember this. Remember the word Vikar. So, so Vikar is something not normal. The mnemonic is Vikar essential relation is that. So not to be Vikar. Vikar essential relation is owner, principal, servant, direct partnership. It's a bit unusual. So I tell you, owner, principal, servant, direct relationship. This is the statement. So the key statement is Vikar essential relationship, or Vikar essential relation is owner, principal, servant, direct relationship. We'll expand into this now. Owner, the first one is for owner and independent contractor. The first one, principal and agent, second relation. Third one is master and servant. Fourth one is company and its directors. Fifth one is partners in a partnership firm. So in order to get vicarious liability, the relation among the parties must be one of this, and there must be a wrongful act committed by one of the person in this related parties, and such act must be committed during the course of the employment which is in effect. So if you consider, if you look into all these things are connected with certain kind of employment. In the event of owner and independent contractor, the employment mean one of them is working, either the contractor is working for the owner. In the event of principal and agent, a agent is working for the principal, or principal has committed something wrong or omitted something towards the agent. In case of master and servant, servant is employed by the master or doing something for him. Company and the directors, so directors are employed with the company, and they are obliged to do certain things which either they omitted or did something wrong. Similarly, the same thing applies to partners in a partnership form. So this must happen during the course of employment, which is in force. So if somebody was in this employment sometime before and now that thing had come up, or anything has been committed which led to this liability, then such liability does not come under vicarious liability if the employment is not in force during the time when such act has been happened. So the next is the types of vicarious liability. So vicarious liability is of 2 types. It's a principal liability and parental liability. Principal liability means the person who committed that act or omission himself will be liable for this. So such kind of liability is principal liability. And the other liability is where parental liability, which means parents or the natural guardians or the guardians who are appointed are liable for the acts committed by the people or the children or the child under their control. That's the parental liability. So there are certain exceptions to vicarious liability. Let's see what are the exceptions. Exceptions is if such act has been committed or such omission has been committed under a statutory duty, then this is not an accepted liability. So the next exception is when such liability is involved with withdrawal of any support which is very essential. And next is when such liability is involved with some hazardous act, or the next one is escaping from the fire, which means the liability, the act of liability has been triggered, happened during the course of escaping from the fire. And the next one is while using the highway. And with all these the 5 key points can be remembered very easily with this another sentence. The liability is exempted when when duty withdrawal hazardous escape using highway. So remember there is some person, let's say his name is Vikar. So Vikar is always good at escaping from his duty. Therefore, is not liable for anything. So you say Vikar is not liable except when his duty withdrawal hazardous escape using highway. Now the next one is about the strict liability. Strict liability is a liability when any person who keeps any hazardous substance in his premises will be held responsible if such substance escape from the premises and causes any damage. Then it is called strict liability. So, if any one person or somebody keeps a dangerous substance in his premises or under his control, and if such thing escapes from his control or from his premises and causes damage to somebody or anybody, then it is called as strict liability, is under the strict liability. So there are 3 essentials for the strict liability. The very first one is there must be non-natural use of land. Whatever the purpose it is intended for, it must be used against that or not for that natural purpose. The second is escape of the dangerous thing. There must be an escape of the dangerous thing from his premises or from his control. The third one is that damage, whatever has been caused, it must be by the dangerous thing. So these 3 are essentials for the strict liability. And the defenses available for the strict liability are, first one is, you may argue that it is the natural use of land, or the other defense is that it's with the consent of the person who experienced the damage. The next one is the plaintiff's own default or own fault, is something that he can claim as a defense for, or you can say it's an act of a stranger that he triggered it or he made it to escape from my premises, or you can say that act of God, which is also called as dismeasure. You can say that such leakage or such escape has been happened because of a common benefit to both. Uh, and then the last defense is statutory authority. So these are the defenses can be that can come into picture in case of strict liability. But however, in case of strict liability, the damages payable are compensatory in nature. So after that mishap happens, then the compensation will be paid to them. Now, the last important liability is absolute liability. The absolute liability is pretty much, very much like strict liability. The only difference is that this absolute liability does not have any exceptions. So you consider the strict liability as it is and take out all the exemptions, then it is called absolute liability. So to repeat what is absolute liability in few different words, absolute liability is generally associated with some industry or enterprise, uh, and there is no defenses available to them for the kind of damages that has been caused by the industrial accident or such leakage or such escape. Damages payable are generally exemplary in nature. So the essentials are it must be an hazardous component involved in this, which it is uh, must be an hazardous component involved in it, which it is inherently dangerous. And well, escape is not really that necessary in this absolute liability. Even natural use of land is part of this essential. So, and it doesn't have any exceptions. So it's got a very wide scope, and it covers public negligence and personal injuries caused. So, and it need not be the own land, the occupier's own land as well. So this absolute liability has popularized, has been highly debated in the case of MC Mehta versus Union of India with respect to the Bhopal gas tragedy case. So, so to make it simple, strict liability minus exceptions is absolute liability. So we made it, everything is pretty simple now. Thank you.